Alex here with part 115 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We're actually going back to the district court. I know the last two videos were a little different. I guess I should be more specific. We're going back to the family division of the district court. In our previous video, I had instituted a new civil action against my ex and the government, and that is the petition for writ of mandamus. And in the video prior to that, we were in the Supreme Court on a publication that was Falcone v. Secretary of State. So we're going all the way back to the family court today, and my ex's attorney has filed her opposition to motion to being held, to her client being held in contempt of court. At this point in time, my mindset was still good. I haven't read this document yet, but I'm sure it's going to be full of the typical deflection, projection, all that other stuff that they usually do. But I do know that following the Supreme Court's ruling and following my filing of the petition, I was buoyed. I was excited. I felt like for once somebody was going to listen. I felt like the Titanic was turning around, and this is going to be one of those videos where most of what I have to say is going to actually come out of the document itself. So let's go ahead and take a look at what my ex's attorney has filed. Here we have my ex's attorney's opposition to motion for order to show cause. In the first paragraph, standard introductory paragraph, you can see that she identifies her client, she identifies herself as the attorney representing her, and she indicates that she has filed an opposition to my motion for order to show cause. One thing that's missing is the date that I filed my motion. Best practices is, as I repeatedly state, try and put that in there just so the court knows exactly what it is you are filing a responsive paper to. Next is the points and authorities. First paragraph, I am apparently asking the court to find my ex in contempt of court for failing to disclose medical dental vision cards and for allegedly violating a separate order regarding the exchange of the homework. Yeah, that's true. Going into the relevant facts. So this is probably a summary. We share joint legal and joint physical custody of our child. In the years following the court's award, I have proven myself to be a prolific litigious parent. Litigiousness is not the same as harassing. The Supreme Court of Nevada has stated this a bunch of times, and attorneys and sometimes judges don't listen to them. Just because you are litigious doesn't mean you are abusing the litigation process. That's what they've stated. And the Supreme Court of Nevada states that it is important for the court to draw the distinction between a litigious parent and a parent who's just trying to harass the other parent. And in this case, if I was a litigious parent, I don't think that I would have gotten my ex parental rights terminated. So let's go ahead and continue. This is just one of her tactics. I've explained this before. In fact, I talk about this in the video, How Attorneys Win. Definitely watch that video. One of the things that attorneys like to do is they try and take you and stuff you into this sort of, they lump you in or stuff you into a group of what the court is used to seeing. And the reason they do that is because they know that the judge will be inclined to just trust the lawyer. So let's say, for example, that judges are very used to annoying self-represented parties that file crazy things and don't know what they're talking about. What the attorney will try to do is stuff you into that, particular group, because they figure the judge isn't going to look into it, because the judge is going to think, yeah, I remember those people. They were, when I was a lawyer, I saw them all the time. Now as a judge, I see them all the time. So if this lawyer is saying that this guy is just like them, he probably is. If the attorney accuses you of doing something that's very rarely done, then the judge may be more likely to say, hold on, I need to, look into this and see if it's true or not. So it's just smarter, at least I think it's a little evil, but it's smarter for them to actually accuse you of something that is extraordinarily common than it is to accuse you of something that's extraordinarily rare or unusual, just because of the fact that the judge often will just trust them blindly. Going ahead and scrolling in health insurance cards. I'm alleging that I don't have medical, dental, vision insurance cards. Oh yeah, gosh, I don't know how the attorney does this with a straight face. So she's literally stating that she's in compliance with providing me the medical, dental, and vision cards because she sent them to me in 2009. Just so you guys know, this is before the court in 2013. So here's an attorney who's not saying, hey, you need to turn those cards over to him so that he can take care of the child if he needs medical care. There's an attorney that's saying, you know what? You were ordered to turn those over to him 4 years ago. Since you turned those over to him 4 years ago, you are technically in compliance with the court's order, and therefore you can keep these cards a secret. That's basically what she's doing. The attorney is facilitating what my ex is doing. She's stating to the court that she's not in contempt of court because the court ordered her to turn over cards in 2009, and she did, in fact, turn over those cards in 2009. Some credit for the attorney, and so a learning approach for me would be to not use the contempt of court mechanism and to instead try and deprive her of legal custody rights. I do eventually figure this out, and I do eventually succeed in doing this. But right now, I don't understand that contempt of court is different from the best interest factors, and that these two things work in different ways. So just to help you guys out, make sure you go and watch my video, Many Fine Lines, because that's the video where I explain exactly what it was I just mentioned. And eventually I figure this out. Eventually I do modify legal custody, and eventually I get sole legal custody. But at this point in time, in 2013, I didn't understand how this worked. And so I'm making a very simple mistake that my ex's attorney is very easily able to defeat. And it hasn't come back, and there's no order yet, but you will see it. So guys, this whole first portion is going to be denied just because my ex turned over those medical benefits cards. There is some stuff in here about our child's dental care, but it's not really in the scope of a contempt of court motion. So I mean, I'm not sure we need to talk about this yet. This is going to be talked about a whole lot more in the videos that deal with the actual motion to modify physical custody. And I'm trying to remember if I filed it yet. I don't think I did. Eventually, you guys will see me file a motion to modify custody on the dental stuff, and then we'll go very in-depth into the dental accusations and defenses. But for now, it looks like my ex-attorney is bringing this stuff up just to make it look like I'm bad or like I'm not cooperating with her, stuff like that. So exchange of homework is the next section, and this is the one I succeed on. What's ironic here is I didn't think I would. I thought that the bigger sell was the medical benefits cards. I thought that this was just something I was just going to throw in there just because I had it. And that's completely the opposite of what happened. When we went to court, the judge tossed out my primary claim, and he took this backup claim that I thought wouldn't go anywhere, and he's going to actually hold her in contempt for that. And that's going to be what actually goes to we go to the hearing on, and that's going to be what she's held in contempt for and handcuffed on. So, exchange of homework. I allege that my ex has violated the court's order regarding the exchange of homework. She unintentionally forgot his homework a couple of times, never willfully or intentionally disobeyed the court's order. She offered several times to scan and send the homework. And I responded that she need not bother. What am I talking about? That's not right. Let's look at these emails, guys. During the exchange immediately before spring break, as I was slamming the car door in her face. What? Okay, so this defense here is that I refused to give her the packet. So she's basically pointing the finger at me. This isn't true, by the way. It's a lie. But she's saying, well, yeah, maybe it's true. Maybe it's not true. But what is true is he did it too. Anyway, that's kind of stuff that annoys the court. If you have something that your ex has done that's contemptible, you should also file a motion for order to show cause so that the court can just deal with both motions at the same time. You shouldn't use that as a defense to their motion, because it's not really a defense to their motion. What it is another motion and another contempt charge separate from that. I'm going to go ahead and scroll down. Babysitter was relinquished. The child to her reported to her that she was sorry she didn't have crayons, that she forgot to help him do it. Okay, so she's blaming the homework on the babysitter. What? Oh, so she's blaming it on me? I don't have it. Well, I guess I did have babysitters back then. This sounds really fishy. And look, there's no affidavit and there's no citation. So this is just kind of a floating out in the middle of the air allegation that I don't even remember, so it doesn't go anywhere. Next we have, it's been a while since the child was in my care and the child was suspended from school. So she's saying that since the child wasn't suspended from school in a long time, that doesn't matter. Arguments. We got the law, and this is the law on contempt of court. We've already talked about this in my motion. It's the same law. And here we have my ex saying she provided the insurance information, which is true, in 2009. So 4 years later, she it just doesn't have to give me the insurance cards anymore. Only when I file motions, apparently. And then next we have the issue of homework exchange, that she never willfully refused to give me the homework, and that exchanges don't always happen at the school. And so somehow, because of this babysitter, there's a problem. She tries this and it doesn't work, but we're going to look into these emails and see if that gives me a little bit more insight as to what's going on. Certificate of mailing, we got the opposition to motion, which is addressed to me, and she served it by mail under Rule 5, which you can do. And then the declaration of my ex, which is just verifying that this document is true and correct. It's being sworn under penalty of perjury that the facts are true and correct. So that's what my ex is signing here. Here we have the motion opposition notice, check boxes into the boxes indicating that my ex does not have to pay a filing fee for the filing of this opposition. Exhibits, we got 6 emails. These should all be new, so let's go through all 6 of these emails. Exhibit 1. All right, what do we got here? Hey guys, I think I'm going to start from the bottom up since that's the actual timeline of when these messages get sent. Okay, so this is the one here. Okay, so she is sending me, finished enrolling him in the dental and vision plans. Here's the links of the plans. She's trying to say that I owe more money. We've already talked about this in the previous video. And then my response, oh no, this is what she's telling her attorney. So this is just the medical insurance stuff. Scrolling down, we got Exhibit 2. And then here we have another series of emails. I'm going to start from the bottom. So I'm telling my ex, I'm still waiting on the eye doctor information, curious about the dental care. And then my ex responds saying the doctor hasn't changed. Notice how she doesn't give any information though. She makes this vague statement of the doctor hasn't changed. So it makes it look like to the court that she's told me and she's just not telling me again. But in reality, she never told me in the first place. So this is a way that these types of people could do this, where they can make it appear as though they're complying with something, but they're really not. And this is sadistic, and I say that because I actually have a video explaining one of the reasons as to why these people do this. If you look at the video, Hide Emotions from Abusers, I go into the sadistic pattern, and I go into why when you show them you're frustrated or annoyed or angry, they actually just go and do it more because they actually get off on it. So this kind of stuff, she knows I hate it, and so she keeps doing it. And it's not very easy to actually prove in court that you knew ahead of time, because even if they don't have proof in writing that they told you, one of the things that they can do is they can lie and say that, well, we had an exchange, and at the exchange I told him who the eye doctor was. So this is, if anyone sees any of these similar approaches to communications, this is a red flag that you may be dealing with a personality disordered person. Scrolling up, we have, don't have Army's eye doctor info. That's why I asked you several times. So this is my response, guys. I'm frustrated. I'm like, hey, what's the info? I don't have it. You telling me that you gave it to me some time ago doesn't help, because I obviously don't have it. So we got, it's not fair to Army that both parents can't be at the doctor appointments because of a petty squabble. I'd like to, I go to class Monday, Wednesday, Friday. So this is my schedule. And then we got child support. Okay, so here's my response on the medical benefits, guys. Child support has medical benefits built into the order. So if you're going to modify child support, you have to get your attorney and you have to get them to file a motion. And this is the reason I say this is because it may be true that medical benefits increase, but at the same time, my income may have dropped. And that's why the courts deal with this by modification, because you can't sort of just cherry pick, hey, since this went up, I want more child support, and then leave other things out that are inconvenient. She is going to play dumb on this, and she's going to end up refusing or demanding more child support money. And I'm not really sure where it goes. I know it ends up going to court, and I'm pretty sure she gets reamed by the judge on it, but we'll see. Here we have, if your income has dropped because you're choosing not to. Okay, so now this is the response. This is the argumentative stuff that I talk about. I explain this in the video communication. So rather than try and deal with this by saying, okay, I'll talk to my lawyer, instead she wants to sort of say, your income must have dropped because you don't want to work full time. She's basically saying it's your fault, and so you still need to pay me more money. If you want to take me to court over a charge of $20, go ahead. Well, she goes to court, but it's not over a charge of $20. It's over a charge of several thousand. And you guys will get to see what happens in that particular situation. Spoiler alert, she loses. So here we go, Exhibit 3. You haven't shown any bills for... Okay, wait, let's start from the bottom again just so everything stays in the timeline. Did you get an email from the dentist on an appointment for our son? If you have a medical card. I have a medical card, but not a dental or vision cards, and I need those per the court's 2009 order. And this is where she responds, well, I gave them to you in 2009, so no. Anyway, so she's saying, she's told me that she doesn't get vision or dental cards, and she's saying he's fine for vision and that he has a dentist. Not that I'd remember it. And these are snipes. I call these snipes. And then she'll schedule another appointment soon, which she doesn't do. She doesn't schedule an appointment and it goes to modification. Next we have, I'm saying send me the info on the dentists that are covered. Your dental insurance is fine. I'm not going to get dental insurance. So this is another stall tactic by her, trying to say, okay, you need to get insurance too. And then later on, she does the same thing when it comes to the bill. She's like, okay, well, you need to pay your half first. And then I do all of these things. I jump through all these hoops, and she still just doesn't get in the care. She doesn't want to do it. Next we have, she's alleging that they want to be paid up front. She says that if I show up and pay for my half, then she'll get it done. So guys, you've seen this brought up before. So right here, remember this email, because this is going to come up and the judge is going to be livid. This email, she says that if I pay my half, it'll get done. But if you look really carefully, she doesn't say that she's going to pay. Look really carefully at this email. She says, well, they want us to pay up front. She doesn't say they want us to pay all of it. She says they want us to pay up front. She doesn't say how much, just that something has to be paid. Her next line says, so if you show up and pay your half, then it will get done. If you, as an ordinary person, read this, you think, okay, well, the other parent wants to split the cost with me and she doesn't trust me, so I need to go pay. But her personality disordered, mental health issue brain is actually thinking, I am not going to pay, but I need to make it look to him like I'm going to pay a half, and at the same time leave myself an escape for later on when I get called out for not paying. So this tells me that she was actually planning the whole time not to pay, and that she was just using this as a sort of obligation or another barrier or another hoop that I have to jump through, in the hopes that, and she's crossing her fingers, that I won't do it. So she's basically doing two things at the same time, and she's communicating it in a way that presents a completely different illusion to the target of her attack, in this case me. So she can't really be called a liar if you look at this, because it doesn't say that she's going to pay half. It doesn't say that she's going to pay at all. She's only saying that it will get done if I show up and pay my half. That's what's crazy about the way they communicate. In fact, if you want to learn more, watch my video communication. More importantly, watch Sam Backman's video, Language as a Weapon. He explains how they do this. It's incredibly, I hate to say it, but it takes a lot of talent to do this, and they do this very quickly. Like, it's almost offhanded, sort of like a subconscious thing they do without really thinking about it. Somebody else would have to really carefully, strategically, almost like a lawyer, put this language together, but not them. Next we have me saying, let's start from the top, that I'm going to file a motion for contempt if I don't get the names of the dental and vision insurance, and then I'm going to file a motion for contempt if I'm not told the name of the dentist, and then I'm sick of our child suffering because all I get is evasive answers and information that I'm entitled to know, and then the purported surgery bill that I owe for, send me the bill and I'll cover half. Okay, guys, she gets made fun of in court for this one. So she says I owe all these monies, but she doesn't give me any of the bills. So I asked her several times and she won't give me any of the bills. Then this goes to court and her lawyer brings it up, and then the judge asks me why I'm not paying, and I'm like, I've asked her 5 times for the bills. And so then the judge looks at her and says, he's not psychic. You can't expect him to intuit the amount of the money. And so this ends up blowing up in her face too. If any of it sounds mean, put yourself in my shoes. Okay, guys, this language right here, put yourself in my shoes, this indicates to me that I still haven't figured out that she has an issue. Because these personality disordered or emotionally immature parents, they can't do this. They're not capable of putting themselves in your shoes. They don't know how to do that. They don't know what that means. And so me at this point putting this in the email makes me think that I really don't know what's going on yet, even back in 2013. It might be something I figured out in 2014 or 2015. All right, and then we got her response, and this is just going to be another argumentative response. So she is saying, hey, you haven't shown me bills for the ER, and this isn't true. She's got them. They're in what's it called? Our Family Wizard. They're there. And the guys, you know what this is? This is just another opportunity to argue. So she's expecting me to respond, yes, I did. And then she'll say, no, you didn't. And then I'll say, yes, I did. And then she'll say, no, you didn't. And then I'll say, well, I put them in Our Family Wizard. And she'll say, well, you should have sent them to me in an email that's an attachment. Any of you that are going through these crazy round and round conversations, those are red flags that you're dealing with a personality disordered or emotionally immature parent. I'm going to scroll back down. Exhibit 4. We got, so we're scrolling here. So I'm telling her, I know you said you would send a scan doc of Army's homework, but once I got off work, I no longer had access to a scanner. And then she's saying, okay, well, you somehow managed to print up all sorts of court documents. Yeah, that's at FedEx. Oh, man. Okay, and then the next we have reread the email, send it before 5 p.m. so I can print it at work. Oh, I get it. So it's not just FedEx. I also have my job that I scan and print from. Exhibit 5. And here we go. After you get in your car and slam the door, wait, let me check to see if this is okay. Good. I'm just making sure that wasn't a previous one. I was still talking to you. Child asked why you were being rude to me. I would suggest you be polite in front of him. This didn't happen, guys. So I've talked about this in the video, how abusers win. And one of the things that they will do is they think that if they say something happened or if they put it in writing, then magically it's true. And the judges understand that somebody can say a lie and somebody can write a lie. Sending me an email like this doesn't just make it magically automatically true. And I talk about that also in the video journals. And then something about a spring break homework packet. She's saying that I got on Friday. This is probably not true because it doesn't come up in court, and if it does, it doesn't go anywhere. Okay, so we got Exhibit 6. And I'm just telling her that Army got suspended for punching another kid in the face. I talk about this in another video. I wish I could remember now. It talked about I was talking about my reflection on our child's frustrations when he was in the middle of the dispute and how it gave him sort of a brain fog, and I can't remember the title of the video now. Sorry, guys. Going into the next document. 34, Rule 34, Notice of Pending Proceeding. And I am just letting the court know that the Supreme Court of Nevada has rendered its decision. They published an opinion. And this is consistent with local Rule 34. You guys have seen, I think, one or two of these before. And then we got a Rule 5 certificate of service indicating I served this document upon my ex's attorney by mail. Going into the aftermath, I filed, one document that was a free filing, so I incurred $0 in costs. My ex's attorney filed one document that was a free filing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have prepared that opposition and reviewed my motion. It was a lengthy opposition too. It had a lot of detail. She would also have to communicate with my ex, get all the emails together. I'm leaning towards 2 hours, and under the circumstances with the detail provided in that document and all of the background work, I think 2 hours is reasonable. 2 hours at the rate of $250 an hour for my ex's attorney comes to $500 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.